So I'd like to welcome Nisha who is a staff attorney at Housing and Economic Rights Advocates, HERA. She focuses her work on tenant advocacy, including helping clients resolving issues related to credit reporting, debt collection, housing discrimination, habitability, and landlord disputes. Prior to joining HERA, Nisha was a housing staff attorney at Family Violence Law Center in Oakland, where she advocated on behalf of domestic violence survivors who were dealing with housing legal issues. Her work there included in-court representation of survivors and obtaining restraining and move-out orders and defending against evictions. Nisha also has spent a substantial portion of her legal career advocating on behalf of system-involved youth. Nisha was a summer legal intern at HERA in 2011 and a postgraduate attorney fellow at HERA in 2013. She earned her JD in 2012. So we welcome you, Nisha, again. Thank you so much for providing this information. I'll be happy to monitor the chat as we go along. And if you have, reminding people that if you have individual questions about a client or someone you're working with, it may not be that we can get to that today, but you will find information about how to get a hold of HERA at the end of our training, and we'll be sure to put that inside the chat as well. So thank you very much, Nisha. Welcome, and I'll let you take it away.
Hey everyone, thanks Beth and Leah for hosting this. I'm excited to be here today. So as Beth said, I am a staff attorney at HERA. I focus on tenant rights, particularly pre-eviction concerns. So we don't provide eviction defense, but later in the presentation, I'll provide resources in case you are experiencing, eviction related needs. So yeah, I focus on pre-eviction tenant concerns. So that includes, anything from habitability to credit and debt collection challenges. We help people fix their credit. And then, so that's kind of the bulk of my work and advising people about kind of what they might be able to expect if they get an eviction notice. So making sure they understand what their rights are, should that happen. And then HERA in general, we provide services related to any sort of kind of like financial abuse situation, whether it's credit and debt issues, mortgage, predatory lending, any type of kind of economic abuse. We also help with student loan issues and estate planning. So I also just wanted to kind of learn from folks who are here today, how are things going? I know everything is really uncertain right now. So if you feel comfortable just sharing, a word about what you're experiencing and how you're feeling in the chat, that would be great to hear.
We'll give it a minute as people probably getting to their keyboards. Morning chaos. Yes, Leah. With small children at home. Man, people are, it's a real slog for people with young children trying to continue life. Nervous for some of my clients.
Yeah, I get that.
Tired, one day at a time, anxious about the future, busy, full of Zoom meetings. Yeah, Zoom fatigue, a real thing. Take some deep breaths.
Definitely deep breaths.
And my eye doctor the other day told me, remember to look away from your screen occasionally and look out the window or look in the distance at that.
That makes sense. Yeah. Get up and take, walks, even if you can't go far, but
right.
That's a good reminder. Yeah.
One day at a time. Thank you, Maria. Someone's in the shelter and some of the families are struggling with distance learning.
Yeah, I'm sure it must be it's such a change to the way life operates, especially if you have kids, I imagine. So.
And linkages, be sure to check out our Help Me Grow has a listserv for alamedakids.org. And I'll put some of those linkages in the chat box after we get started. So thank you everyone for participating in that.
Yeah, thank you. And then just so you know, I'm happy to take questions, as you have them. So if you have any questions, just type them in the chat box. As Beth said, I can't answer kind of personal questions, so just keep that in mind. If you have a personal question, this is a public space, so I imagine you probably wouldn't want that confidential information to be shared with other people, but we will have information at the end of the presentation about how to contact HERA so you can get set up to speak with someone, an attorney, individually, if you have a question or you believe a client has a question that you would like to have answered. So, okay, so let's see. Okay, so here's the agenda for today. I'm going to start out with tenancy relationships and rights. So this is about kind of the different setups that one might have in a rental situation. So if you have roommates, typically it's either a co-tenant situation where everyone is on the lease together, or there's an arrangement called a master tenant, where the master tenant is the only one on the lease, and then the other roommates are what's called subtenants. So I'll explain, kind of the different types of relationships and what that might look like and the different roles and responsibilities. Then I'll go into basic tenant rights, so that relates to what to do if you have an issue with habitability. What kind of rights do you have for notice? If the landlord wants to try to evict you, what are your rights in that scenario? What are your rights related to security deposits? Kind of basic components that go into a landlord-tenant relationship. Then I'll discuss good and just cause and rent control. So just cause essentially means, what are the reasons why a landlord can evict a tenant, and certain jurisdictions have just cause and some don't. But California recently passed a law that provides just cause protections to the whole state. So it means that landlords can only evict for certain specified reasons, but unfortunately there are exceptions to that law, which we'll get into. Also discuss rent control at the local and state level and what that looks like. And unfortunately, there are also exceptions to those rules. Then we'll discuss COVID-19 and eviction protections and prevention. So some of you might know that there is a recent state law that was passed related to COVID-19 evictions, particularly for non-payment of rent. So there's some more protections around that type of eviction, but there's also local protections, and then a federal order from the Center for Disease Control related to non-payment of rent evictions primarily. So I'll discuss those different laws and again what the exceptions are and kind of the basics and what the process is. These laws are changing and they're complicated, so just bear with me. What I'm talking about today is up to date, but it's possible that these laws might change in the near future. And then we'll open up to questions, any questions we didn't get to throughout the presentation. And then I'll have more information about Alameda County resources related to what we're talking about today. Okay, so now let's discuss legal rights related to roommates, subletting, and shared living. Okay, so let's just get into some basic definitions, what a co-tenant and subtenant is. So co-tenancy is when all roommates are on the lease together. They all pay the landlord directly. A possible exception is if a roommate is not on the lease but pays rent directly to the landlord. So that would still probably establish a co-tenancy relationship, because the other roommate, not even if they're not on the lease, they have a direct relationship with the landlord. It can get a little nuanced and kind of a gray area, but in this case, it looks like there is a direct relationship between that roommate and the landlord. And so a subtenancy is when only one tenant is named on the original lease, and then the other tenant or tenants are there with the permission of the master tenant. So the master tenant pays rent to the landlord, the other tenants don't, the subtenants don't have any direct relationship with the landlord. So this is kind of what it looks like visually. So a co-tenant, they have a direct relationship with the landlord, their name is on the lease, they pay rent directly to the landlord, even if, let's say, they write a check and one tenant just gives the check to everyone else, I mean, to the landlord, the co-tenant is still providing the check to the landlord because they're listing the landlord's name. So there is a direct relationship. And then in the other scenario, there's the subtenant and then the master tenant. So the master tenant, as I mentioned before, they're the only ones named on the lease, and the master tenant provides all of the rent each month to the landlord directly. And then the subtenant is responsible for providing rent, their share of the rent, to the master tenant. And there's usually a sublease between the subtenant and the master tenant. Okay. Okay, so here's just a little more information. So all tenants sign the lease with the landlord and pay rent directly to the landlord in the co-tenant relationship. And then all tenants are jointly and equally responsible for paying rent and complying with the lease. So this means that, if there's an issue, if there's some sort of legal issue or one tenant doesn't pay rent, the landlord can go after the other tenants for that rent that wasn't paid. If it eventually leads to some sort of legal situation or an eviction, usually what will happen is the landlord will list all of the tenants known on the lease on the eviction paperwork. And let's say, a co-tenant moves out 2 months before the landlord files the eviction, even though the co-tenant isn't living there anymore, unless there's some sort of understanding that their name would be removed from the lease, and their name is removed from the lease, the landlord can still go after that co-tenant for the money that wasn't paid in rent. And the landlord can choose to evict all of the tenants or just one. Okay, the right to sublease. So in California, a landlord may be able to refuse to allow a tenant to sublet if and only if the lease clearly and explicitly prohibits it. So the lease needs to say clearly, subleasing is not allowed. If the lease requires a landlord's permission to sublet, the landlord cannot, quote, unreasonably withhold consent to sublet. So the original tenant remains responsible for the terms of the lease. So that means the original tenant is responsible to ensure that the subtenants don't violate the lease, because if the subtenants violate the lease, it could fall on the master tenant. The liability could fall on the master tenant for the subtenant's actions. And then, so some cities may have additional rules regarding subtenants. So for example, regardless of the lease prohibition, a landlord can't unreasonably prohibit existing tenants from replacing a tenant one-to-one that moved out. So that's in Oakland and Berkeley. And then the master tenant can't charge subtenants more than they pay in rent and rent has to be proportional to space, and that's in Berkeley. Okay, so I don't know if folks had a chance to read an article I had sent around, but this was in East Bay Express. And so I'll just read the quote. When the unit was rented, the economy, this is the landlord speaking to a master tenant. When the unit was rented, the economy was in the toilet. You were the best applicants, Lane wrote in an email to her renters. Since the recession, people have put their lives back on track and moved on. In a subsequent email, she continued, the local economy here is spilling over with people far more accomplished than her. Her is one of the subtenants, than her to select from. Lana wrote, explaining a rejection. For that apartment, at that rent, in this economy, you should be getting young professionals, grad students, or master grads. Just because the rent is extremely low does not mean I accept extremely low quality tenants. Okay, so let's just take a moment to think about this issue and what the landlord said. Do you believe that she was allowed to deny the prospective subtenants based on what she described and what their profession was and what they did?
Are you wanting people to respond to the question in the chat, Nisha?
Yeah, yeah, chat would be great.
Okay, so it says no, someone says no, she was not. And that could be profiling, that isn't legal. Isn't that considered discrimination? So yeah.
Yeah, I mean, it would be discrimination based on source of income, which is illegal in California.
And someone says, I'm not sure.
Yeah, I mean, it's not necessarily a slam dunk, but to me, it seems pretty clear that she was making unreasonable restrictions on subtenants because these people were allowed to pay. It's not that they didn't have the money, but she was discriminating based on, you know, what type of job they had. And one of the subtenants was actually a school teacher, you know, so it's not that that should matter, but the point is these people had the ability to pay and she was refusing them based on a factor that shouldn't be, you know, considered in assessing a subtenant or a tenant.
Right. There's a question, a couple of other questions that have come up along the way. Do you want me to read the questions or do you want to kind of wait and do you have a question period for those, Nisha? How would you like?
I'm happy to take questions as they come. I might not be able to answer them, but.
So the question currently on the chat is about a long-term partner, unmarried, wanting to have one of the partners move out, partners and unwilling to move. Does it depend on whether or not the name is on the lease? So what are the rights to get the person out? Sounds.
Yeah, I mean, that's a little tricky. You know, if the person's name is on the lease, it would definitely be harder. But they have rights if they've lived there, you know, for at least 30 days. I mean, if there is harassment or discrimination or, you know, some sort of abuse situation, that there might be, you know, the ability to get a restraining order with a move out order. But right now, especially with a coronavirus, I know that there's a lot of hesitance in the courts to
do that,
to evict or you know, require a move out order. So yeah, I mean, it would probably be kind of dependent on some factors that
Yep.
I don't know about. But yeah, you're welcome to call HERA or this person, whoever that person is. Or, there's usually like a family justice center in each county, or, a family law referral service. You might be able to find, if you want to talk to an attorney about that. HERA doesn't provide family law services, but it does look like this involves some family law too. So
there's a question about owners requiring 3 times the income in order to rent. And is that income discrimination?
I don't believe so. I would need to know a little bit more, but usually it is, from what I understand, it is reasonable for a landlord to have, certain income requirements from prospective tenants. They just can't discriminate based on the source of the income.
Okay.
So if the prospective tenant's income is, twice the amount of what the rent is, typically, from what I understand, landlords would prefer, for income to be, for the rent to be, a third or at the most a fourth of what the total income is. Yeah. So the rent would be,
right, a third,
significantly less than 50%. So they do have certain rights around kind of requiring a certain level of income. I would need to have some more information.
All right. There is someone that has their hand up. I don't know if you're wanting to take a question. I want to keep us moving.
Yeah. Why don't we wait a little bit?
So James, we're going to wait a little bit. I see your hand is up, and we're going to just wait a little bit, try to go down the road here a little more, and then see if maybe your question can be answered as we go further on. But if not, we'll get it.
Yeah, we can definitely save it for the end if
yeah,
you don't
sounds
answer
good.
it. Okay, so master tenant responsibilities. Okay, so the master tenant is responsible for paying rent to the landlord for all tenants, as I mentioned. They must collect rent from subtenants, and the subtenant doesn't pay the landlord directly. The master tenant must ensure the subtenants follow the lease terms. As I mentioned, the master tenant could face liability for violations of the subtenant. So even if the master tenant doesn't do anything wrong, if a subtenant violates the lease, it could fall on the master tenant in terms of liability if the landlord decides to pursue something. Okay. The master tenant has the authority to evict subtenants, but must follow all the same local, state, and federal laws that the landlord must follow, and retaliation is prohibited. So if the a subtenant violates the lease in some way or the sublease, the master tenant would have the authority to evict the subtenant. The master tenant is effectively the subtenant's landlord, but the master tenant does need to follow all of the same laws in order to evict properly, and retaliation is prohibited. So the master tenant can't just, evict a subtenant because, for personal reasons, or they didn't like that the subtenant was trying to, invoke their rights in the housing relationship. If the subtenant has committed violence against the master tenant or other subtenants, the master tenant should call the police and consider getting a civil harassment order against the subtenant. So civil harassment order is different from a restraining order. A restraining order for domestic violence, there has to be some sort of either family relationship or, intimate partner type of relationship, marriage. So typically, a roommate situation doesn't fall into that category. So a roommate relationship would most likely require a civil harassment order. it's kind of a similar process to apply for one, but differences in how the burden of proof that's needed, the amount of evidence that the person seeking the order would need to provide to the court. Okay, so subtenant rights and responsibilities. So as I mentioned, the master tenant is effectively the landlord to the subtenant, and the subtenant should read the master lease. So definitely a request if you're in a subtenant type of situation, or a client is, subtenant should ask to read the master lease before signing the sublease. You want to ensure that the master tenant isn't violating the master lease by subleasing when they're not allowed to. And you want to make sure that your share of the rent is fair and equal. So you want to make sure, you know, you're not overpaying and the master tenant is paying a small amount of the rent. And then you'll also want to have a sublease with the master tenant, which lays out kind of the, you know, the rights and responsibilities. And usually the sublease will just reflect what the master lease says. And then in most cases, if just cause protections apply, so I'll discuss just cause later. Landlords, but it essentially means landlords can only evict for certain specified reasons. If just cause applies, in most cases, they'll also apply to subtenants. So the master tenant will need to follow the just cause rules. Okay. Okay, so now these are a list of some of the basic tenant rights we'll discuss. Habitability, limitations on landlord entry, freedom from retaliation, security deposits, right to notice, month-to-month versus term lease, opportunity to cure, and the statewide law regarding good cause and rent control. Okay, so basic tenant rights, habitability. Tenants have a right to live in a habitable residence. Landlords are legally required to provide habitable units. So that includes, you know, rental units must be free from mold, asbestos, lead, safe and intact structural elements, including stairs, walls, roof, plumbing, electrical. Landlord must provide heating and hot and cold running water. Conditions must be sanitary and clean, and there must be adequate pest control. And the landlord must take reasonable efforts to prevent break-ins and criminal activity on the property. So if a tenant notifies the landlord of major repairs needed or another major habitability problem, for example, rodent issue or serious plumbing issue, and the landlord fails to fix the problem timely despite knowing about it, the tenant may be able to withhold rent until the landlord fixes the problem, or the tenant can pay for repairs themselves and deduct a portion of the rent. So this is, you know, really kind of a last resort action that tenants should take, and it can result in it's not very easy to make this to meet this standard. So it's really important that if a tenant is experiencing major habitability problems, that the tenant adequately documents everything. That the habitability problem also can't be the fault of the tenant. So if you know, let's say a rodent issue or a leak issue is the fault of the tenant can't then try to deduct rent. So yeah, it's really important that tenants do, before deciding to take this route, have, you know, written records of reaching out to the landlord, telling the landlord what the problem is. Then the landlord still, you know, not coming to fix the issue, or maybe the landlord just keeps on putting it off. And it does need to be a serious problem. It can't be like a minor issue, like, let's say, you know, a drawer is broken or something like that. So take pictures and have, if you can use email with your landlord, make sure to have, the timestamps and keep all of them, and take screenshots if you text with your landlord. And then depending on the extent of the habitability problem, the landlord may be required to relocate the tenant temporarily and pay for hotel costs while the unit is being repaired. So I had a case at my last job where the tenant, there was flooding. So one of the pipes burst and it wasn't her fault. And so there was significant damage and there was also mold. And so the landlord in that case was required to pay for her hotel costs while the unit was being repaired and renovated. Okay, so basic tenant rights, limitation on landlord entry. When and why can a landlord enter a tenant's unit? So in general, a landlord must give, quote, reasonable written notice to the tenant. So reasonable is generally understood to be 24 hours. And typically the reason to enter is related to making agreed upon repairs, to show the unit to a prospective renter if the tenant is moving out, or to do a pre-move out walkthrough, which the tenant has requested. In limited circumstances, a landlord can enter the unit without prior notice. So that's, if there's an emergency that requires a landlord to enter, for example, a flood or a fire, the landlord obtains a court order. Usually this relates to some sort of habitability problem. The tenant has abandoned the unit or the tenant consents. So be mindful of excessive attempts by the landlord to enter the unit. This could be an indicator of harassment, retaliation, and or discrimination. So, we've seen this happen where the landlord kind of repeatedly asks a tenant to enter. And even, let's say, even if a tenant does agree, there might be some level of kind of pressure or feelings of coercion in that situation. It might feel harassing if the landlord doesn't really have a reason to enter. You might want to kind of consider what's going on. Sometimes we've seen this a lot in Oakland, though I imagine it's probably happening everywhere. There's some level of like repeated requests from a landlord to enter or kind of harassing behavior, and it seems to be a way to just get the tenant to feel so kind of exhausted by what's happening to move out, and then the landlord is able to raise the rent. So usually this happens in rentals where the rent is quite low. So yeah, just be mindful, and you might have, depending on what's happening, you might have certain rights, under local housing law and state law, to be free from retaliation. So just keep that in mind. Okay, so limitations on, yeah.
We had a quick question about bed bugs.
Okay.
Is that, I'm assuming that is also something that is makes a place uninhabitable, but because the origin of them is unclear, that's probably a sticky matter, I would imagine.
Yeah, I mean, that's definitely, there's usually like a bed bug, notice advisory in a lease. So that's definitely an area where
take a look at
habitability could be a serious concern. But yeah, I do imagine that, and I've seen cases where there have been, pest issues, and the landlord usually tries to blame it on the tenant in some way. So just, as much as possible, if you could have, pictures, or if the tenant can have pictures just showing how clean they keep, the unit, and again, just documentation to support your the tenant's habitability and cleanliness. And then I also know in if the tenant has a Section 8 voucher or, other forms of public housing, the housing authority does an annual inspection. So, and then the housing authority also has reports. So that might be something that could help support a tenant in that situation. If the housing authority doesn't see anything wrong with how, during the inspection, with how the tenant has been maintaining the unit, that could support, a case that it wasn't the tenant's responsibility or fault.
Okay, thank you.
Yeah. Okay, so let's see here. So in limited circumstances, a landlord can enter the unit without prior notice. Sorry, did I already talk about this? Yeah, so yeah, just be mindful of excessive attempts by the landlord to enter the unit. They can't just enter whenever they feel like it. They need to have some sort of reason. Okay, so basic tenant rights, security deposits. So when a prospective tenant is looking for a rental, just keep in mind that there are limitations on the amount the security deposit can be. So for an unfurnished unit, it can be 2 times the amount of the rent. And for a furnished unit, it can be 3 times the amount of the rent, and that's the maximum. So allowable deductions, when you're moving out, obviously, tenants typically do their best to leave the apartment as clean and sanitary and intact as it was when they moved in. It's definitely a good idea to take pictures when you first move in, especially if you live somewhere for a long time. So take pictures when you first move in to show the condition. And then when you move out, the landlord is allowed to deduct for damages beyond normal wear and tear. So, for example, a landlord can't require a tenant to paint the unit before they leave. Paint fading is just kind of a normal wear and tear type of example. But if there's damage to the wall, or if, somebody painted on the wall, in a different color or something, that would be an example of damage beyond normal wear and tear. So the landlord can also deduct from the security deposit for costs to clean the unit to make it as clean as it was when the tenant moved in, and to cover any unpaid rent. The landlord must return the full portion of the security deposit, or the full security deposit or a portion of the security deposit that wasn't deducted to the tenant within 21 days after the tenant moves out. There are certain requirements that the landlord must follow if the landlord deducts any portion of the security deposit. So the landlord must send the tenant any remaining refund, a written letter explaining the deductions, an itemized list of the deductions, and copies of receipts unless the repairs were less than $126 or tenant agrees that the landlord doesn't need to provide the receipts. Okay, so now we're going to talk about basic tenant rights related to rights to notice, specifically in relation to ending a tenancy or an eviction. So this is slightly different now because of COVID-19 and the different laws that have been passed, but those laws are temporary and there will be updates to them, the California law, in January. But so just keep in mind that these are affected right now, and I'll discuss later on kind of what it looks like in terms of COVID-19, but just in general, this is good information to have. So cure period. So in most cases, tenants have a cure period after, for example, a non-payment of rent notice or a lease violation notice. So what will generally happen, and what folks are probably familiar with in terms of what the laws are, is before an official eviction is filed or a tenant can be served with the actual summons and complaint, which is the lawsuit itself, the landlord needs to serve the tenant with a notice. So for example, a 3-day notice to pay rent or quit. That's not 3 days anymore right now because of coronavirus, but that's probably what most people are aware of. So within those 3 days, the tenant has the ability to cure, which means pay the rent within those 3 days. And then the landlord can't proceed with the next step of the eviction process. Or if there's some sort of lease violation that's not major and serious, the tenant has the right to cure that issue. However, in some cases, serious cases, the tenant doesn't have the opportunity to cure, and the landlord can just proceed with the eviction as long as they provide the proper notices. So for example, if the lease violation is egregious, for example, nuisance, or the tenant has caused substantial damage to the property, criminal activity on the premises, a cure period isn't required, and the tenant may be required to vacate the unit within a certain time frame, typically 3 days, without the opportunity to fix the issue. Just keep in mind that this is affected by coronavirus. Okay, so notice of termination. So in a month-to-month lease, let's say, the tenant hasn't violated the lease, the tenant hasn't done anything wrong, there isn't any issue with habitability. So in a month-to-month lease, if the tenant has been living in the unit for at least 30 days, the landlord must provide the tenant with 30 days written notice to move out. If the tenant has been living in the unit for more than 1 year, the landlord must provide the tenant with 60 days written notice. If it's a fixed term, for example, 1 year, in most cases, the landlord cannot terminate the lease without cause. Without cause means without any sort of reason at all before the end of the term. So the lease will expire at the end of the term unless the landlord and tenant agree to renew.
There's a question if tenants can terminate the lease, and I'm assuming a tenant can, but there might be consequences.
For month to month or fixed term?
I think it's fixed term because it says lease. I'm assuming that's like a year lease or something.
Yeah, the tenant can, but they'll usually have to pay, some sort of fee to break the lease. There are certain situations where a tenant won't be liable. So, for example, in domestic violence cases, if a survivor needs to flee the apartment, there is a law in California that allows the tenant to break the lease early and only be liable for 14 days rent, but they have to follow the right process, which includes notifying the landlord of the domestic violence situation, providing some sort of documentation. So it could be a police report, a temporary restraining order, or a letter from a third party agency,
Great,
or
thank you.
counselor, that sort of thing. So yeah, I mean, in most cases, the tenant, if they break the lease early, they'll have to pay a fee. But there are certain circumstances where the tenant can be protected from liability.
Okay, thank you.
Yeah. Okay, so good and just cause and rent control. So cities can enact ordinances to protect tenants from displacement. So just cause and rent control laws, a lot of them have been implemented because, for example, in cities like Oakland and the East Bay and San Francisco too, just obviously everyone here knows the Bay Area has gotten really expensive to live in. These laws have been enacted to ensure that tenants aren't being displaced, just so landlords can, build more and raise the rent to extraordinary levels. So just cause and then rent control are two different types of laws, but most, if a city has one type of law, usually they also have the other type of law as well. So rent review and mediation. So in some cities, like Berkeley, Oakland, City of Alameda, Hayward, and Fremont, in order to raise the rent, a landlord will have to go through a certain process to have that reviewed, and the tenant has certain rights related to the rent increase. So there are certain processes that the landlord will have to follow in order to raise the rent. And rent review and mediation. So that is similar. It's the city is allowed to review whether the rent increase was legal, and tenants, if tenants want to oppose a rent increase, I mean, they don't always have, you know, a justified reason. Sometimes many times the landlord is actually raising the rent legally, but tenants do have certain rights in order to challenge a rent increase. And usually, you know, the city will have information on their website about how to challenge it. So just keep that in mind. The city will have the process laid out. If it's not on their website, definitely call them to understand what your particular rights are regarding rent increases. So as I mentioned, just cause means that the landlord can evict for only certain specified reasons. So Berkeley, Emeryville, Oakland, Hayward, Union City, and City of Alameda. And then sometimes, you know, one of the specified reasons might be related to something the tenant hasn't done, but the tenant still needs to move out because the habitability of the unit is so just egregious that the landlord needs to either substantially, you know, renovate it or demolish it in some cases. So in those cases, the landlord might be required to pay for a relocation. So for example, 1 month rent, that's in the new law, AB 1482, which I'll discuss later. And then in some cities like Oakland and Berkeley, they have specific relocation dollar amounts that the landlord needs to pay. So just keep in mind, some local ordinances might have different rules regarding relocation and just cause. Okay, so statewide just cause and rent control. So this is AB 1482. It's also called the Tenant Protection Act. It was passed last year. And the general code section is Civil Code 1946.2. So in general, there are two types of just cause. One is no fault just cause. So this means the tenant hasn't done anything in any way to warrant being evicted. So for example, the owner or the owner's family member wants to move in. In AB 1482, the tenant, if it's in the lease that the owner or the owner's family member may move in, or the tenant agrees in writing, that could be an example of no fault just cause. The landlord has an intent to demolish or substantially remodel a property. The landlord withdraws the unit from the rental market, or the tenant needs to vacate because the landlord needs to comply with a court order related to habitability. And as I mentioned, the landlord may be required to pay for limited relocation assistance in the habitability issues, as long as the habitability problem was not the fault of the tenant. So at fault just cause, this is when the tenant has done something, for example, violated a material term of the lease or engaged in other specified actions which are listed in the law. So for example, not paying rent on time, criminal activity on the premises, refusal to allow the landlord to enter lawfully. So in AB 1482, before the coronavirus, there were exceptions to when just cause would apply. But now, right now, until I believe beginning of February of next year, just cause applies to all tenants in California. So, or AB 1482 just cause applies to all tenants in California. But just keep in mind that that's not permanent. So here are examples of the exceptions to AB 1482 just cause. So if a tenant lives in, or, a person lives in a transient and tourist hotels. And again, these, right now, COVID, the exceptions to just cause don't apply. So housing in a nonprofit hospital, religious facility, extended care facility, student dorms, that was listed twice, a duplex where the landlord lives on the property, the unit was built in the last 15 years, single family home not owned by a corporation. So this is kind of a confusing exception. So single family home that is not owned by a corporation, a real estate investment trust, or an LLC, which is another type of kind of business entity where that LLC has one or more corporate members.
Yeah, this is confusing.
Yeah. So I mean, I often still need to like reread it multiple times.
Yeah, and there are questions coming in, and I think some of these questions we'll try to get to.
Okay.
But some of them, everybody, I just want to say, are pretty detailed, and because the codes are so complicated, we may have to have you call HERA. But anyway, it's really interesting how complicated it is. Thanks.
Yeah. Okay, so statewide rent control under AB 1482. So under this law, so unfortunately, the statewide rent control has, from what I understand, has not been extended to all tenants in California. So rent cannot be raised by more than 5% of your local consumer price index. So each city will have on their website an indication of what the consumer price index is. So the rent cannot be raised by more than 5% plus your local consumer price index, or it can't be raised by more than 10% of the rent, whichever is lower. So this rent cap in the law will expire January 1st, 2030. Rent can only be increased twice in any given 12-month period. The landlord must provide proper rent increase notice to tenants. So there are certain requirements in what the notice must include. And then the exceptions, tourist hotels or hostels, nonprofit hospitals, religious facility, extended care facility, student dorms, duplex where the landlord lives on the property, housing restricted by a deed, regulatory restrictions. So this is kind of low income affordable housing. Single family homes where a home, again, so this is essentially, sometimes I think about it from the other, I kind of try to flip it. So if someone lives in a single family home and the owner is not a corporation. So we had a case where someone was living in a single family home and the owner was an LLC, but none of the members were corporate. So in that case, rent control did not apply. I know this probably sounds really confusing, but unfortunately the way the law is written is really confusing. There are all sorts of like double negatives. So if a tenant lives in a single family home, just starting off the bat, you'll want to look further into this law because it is possible that their rent can be increased legally. Of course, if it is a rent increase that's significant, you'll still want to like do some investigation to see if there's anything that can be done to stop that from happening. There are laws preventing price gouging, especially during a pandemic or some sort of emergency. So that might be an option too. That's something that we have been doing some research about. So that essentially means if rent is raised by more than double, which we've seen recently, and unfortunately it was a legal rent increase according to this law, but there might be other laws that could apply because, you know, if somebody's rent increased by more than double during a pandemic, you know, you basically essentially feel pressure that you have to move out. So there might be kind of more subtle ways to try to address that and prevent the rent from being increased. So just something to think about. And then also if the certificate of occupancy for the property is less than 15 years old. Okay, so accessing rental housing, we've seen this, you know, on credit reports, when can an eviction be reported on your credit or in a tenant screening report? So generally an eviction can be reported in California only if the landlord gets a judgment within 60 days of filing the unlawful detainer. So getting a judgment means winning, or upon order of the court. So right now with coronavirus, evictions can't be reported at all for non-payment of rent reasons during COVID-19. So this is in the bill we'll talk about later, which is now law. It's called Assembly Bill 3088. So sometimes, you know, we do see that a credit issue, or, you know, a landlord refusing to rent to someone based claiming credit could be a sign of discrimination. So for example, maybe a tenant applies for housing and the landlord just says, you know, denies them and says your credit report, you know, is not satisfactory, but doesn't provide the tenant with a copy of their credit report or the information about how to get a copy of their credit report, which is required under California law. If a landlord denies a prospective tenant an apartment and says it's partially or all of because of their credit, the landlord is required to provide a written statement to the tenant explaining how to get a copy of their report. So, you know, if the landlord doesn't do that, it could definitely be a cause for concern. You know, we've also seen situations where a prospective tenant is a senior and a person of color, and they were approved kind of, you know, all up until the point where the landlord saw the person in person. So I actually got to see what they looked like, and then they were denied and gave a vague reason. So it's definitely, you know, if you're denied or if a client is denied and the reason is credit, the person will definitely want to make sure to follow up in writing to get a copy of that report that the landlord claims they denied them for. And it could, depending on, you know, what documentation evidence exists, it could be the basis for a fair housing claim. Okay, any questions about that? I don't know if we've gotten questions in the chat, but.
Yeah, there was a question about AUDs, that's part of a single family home.
Okay. Yeah, I'm happy to kind of
Yeah, so I'm a little confused. So the person, maybe we could get a little bit more information about that question. And then there's a number of other questions. So when you're ready to launch into some questions, I have some lined up here for.
Okay.
Do you want me to go with them?
I can answer the question about the single family homes.
Yeah. So Maureen, that was your good question. I wonder if you have a little bit more to say about that. She says in a single family home, if a single family home's exempt from just cause, what if a person is renting out the ADU?
The ADU? I'm not.
I mean, I think she means if there's another unit that's connected, that's not the house, but it's another accessible dwelling. Dwelling unit. Okay.
So right now, just cause applies to everyone.
Okay.
Until February 1st, I believe.
Okay.
Yeah, but yeah, that's a kind of complicated question. I'd probably have to sit with her a
Yeah.
little bit. I welcome her to call HERA.
Yep.
I might need some of these questions, especially for
Yes.
the
Yeah.
code section itself. It requires me to kind of just go back and read the code to make
Yeah,
sure.
and a lot
Yeah,
of the questions
get it
we're
right.
getting, I think we'll hold till the end. We'll let us
Okay.
go through all our information and then we'll go back and we'll go through and say, oh, that's a question that needs to go to HERA. I can answer that quickly. So
Okay.
let's keep the content going. So we can get through that. That's great. Thank
Okay.
you.
Yep. Okay, so now let's do a couple polls, true or false questions. I think Beth earlier is going to set up the little question to show up on your screen.
A landlord returns half of a tenant's $1,000 security deposit and provides itemized list of the deductions, but did not provide receipts for materials. And tenant never agreed that landlord didn't need to provide receipts. Landlord was required to provide
That should say receipts.
receipts. Was that true or false? Looks like most people think it's true.
Yeah, that's true. We've seen this a lot. Landlords are required to provide receipts and they just don't. So definitely, if you're a client or in that situation where you're moving and the landlord doesn't provide you with receipts, you have the right to request them, but they're required to provide them unless it's under $126 or you agree, the tenant agrees that the landlord doesn't need to provide receipts. But it's important because I think oftentimes I've seen landlords take more money than really is fair. So just keep that in mind. Okay, so the second question, can we pull that up? Master tenant has paid the full rent to landlord on time, but the subtenant has not paid their full share of the rent to the master tenant for the last 2 months. The master tenant can begin an eviction lawsuit against the subtenant. Is that true or false? Yeah, so in this case, in this example, the master tenant is allowed to proceed with an eviction against the subtenant, but they would have to follow all the correct laws and provide proper notice. So again, it's essentially the master tenant is the subtenant's effective landlord. So the master tenant would have to follow the same rules that the landlord, him or herself, would need to follow in evicting tenants. So I'm not sure if you wouldn't mind repeating the question that a participant had.
Yeah, the participant asked, what recourse can someone have if a roommate / co-leaseor on a 1-year lease left 6 months into the rental?
Okay. So is their name on the lease? So it's a co-tenant. It's not like a subtenant master tenant relationship.
It says co-leaseor. So it's let's see. Yes. So I guess their name is on the lease.
Yeah, I mean it's a little complicated if that rent is being covered by somebody else, or if is the landlord still getting their full rent, or is one of the co-tenants covering for that person? So the co-tenants would have the right in that case, most likely to request, a one-to-one type of situation where where they can replace that co-tenant. They would have to talk to the landlord though, and it would kind of depend on what's in the lease. But in that situation, a co-tenant can't evict another co-tenant. Only a master tenant can evict a subtenant. So in that case, it would have to be the landlord themselves. If, I mean, it's a little tricky because the person is already out of the unit. Another option could be small claims court.
That's what I was going to suggest. Small claims court. Good.
Yeah.
It sounds like this person might need to call HERA and get a little into the details. So
yeah.
Thanks.
Yeah,
Nisha.
that's fine. Happy to talk to that person or another attorney in our office. Okay. Okay, so now we're going to talk about COVID-19. And yeah, just to give, a disclaimer, these laws are really tricky, and we're all trying to understand how they fit together, and they're being regularly updated. So just, keep that in mind. What I'm saying today might change, might be different, a month from now. But I'll, do my best to just give information, which I hope will be helpful for everyone. Okay, so a moratorium. What is a moratorium? A moratorium is a temporary ban of certain activities. So if folks remember, earlier this year when the coronavirus started, most cities and counties in the state of California passed an eviction moratorium. They all kind of varied at different levels, but the purpose was to reduce the likelihood of coronavirus transmission and related public health and welfare risks. Now, a lot of those moratoria have expired. The state of California had what's called the Judicial Council Rule, which it was passed in April, but it expired at the end of August. And so that rule said that throughout California, tenants cannot be evicted for reasons other than related to public health and safety. So that statewide rule is not in place anymore. And what the California legislature did to address the problem was they passed AB 3088, which I'll discuss coming up. Also, at the federal level, the Centers for Disease Control issued an order related to non-payment of rent evictions primarily, but it does affect other types of evictions too. And then Alameda County passed a moratorium in the spring, and that's still in effect. So that is actually, from my view and what I've read, that seems to be the strongest in place. So if your client or you live in Alameda County, definitely you'll want to keep this in mind. Okay, so we're going to talk about the CDC eviction moratorium order. So this temporarily bans evictions for non-payment of rent, and it expires December 31st of this year. So the non-payment of rent does not have to be related to COVID-19 financial stress or loss of income. That is required in California's law. So the CDC order does apply in California. We've seen, other advocates use it to try to get protection for their clients. It requires tenants, if they want to invoke the CDC order, to first seek out government financial assistance to pay their rent. And the tenant will be required to provide a declaration to the landlord stating they're paying as much as they can, and would be homeless or have to live in close quarters with other people if they're evicted. And then the declaration also includes, stating that they've sought government assistance, and there are income requirements. So in order to be eligible, either you have to have a 2020 income cap of $99,000 if you're a single tax filer, or $198,000 for joint filers, or the tenant received a CARES Act stimulus check, or they had no reportable income in 2019. So the CDC order also appears to prohibit all no-fault evictions. So if you recall when I was discussing good cause, there's at fault and no fault. So no fault is when the tenant hasn't done anything wrong. Okay, so now California, this is definitely complicated. So this took effect on August 31st, 2020, when the Judicial Council rule expired. So the purpose is to provide relief to tenants, homeowners, and small landlords during the COVID-19 crisis. So there are also provisions of AB 3088 that apply to homeowners and small landlords, which I won't be discussing here today. But HERA does have people who can answer questions if you or a client have, or a homeowner or a small landlord and have questions about this. HERA can answer some of those questions. So AB 3088 is not an eviction moratorium because it doesn't temporarily outright ban certain evictions, but if tenants follow the requirements in the law related to non-payment of rent evictions, they may be able to avoid being evicted. So the basics of this law, it applies to evictions where non-payment of rent is a reason for the eviction or the landlord wanting to pursue an eviction. So non-payment of rent evictions were able to begin in California on October 5th, 2020. If non-payment is the reason, the landlord must provide a cover sheet, stating whether the eviction is related to non-payment of rent. So the landlord now must provide a cover sheet when they're filing an eviction, stating whether or not it's related to non-payment of rent. So no cause evictions are not allowed for any tenant until after February 1st, 2021. So this is, again, when there's no reason why the tenant should be evicted. So as I mentioned, this extends just cause to all tenants. So that is essentially the same thing. If a landlord wants to evict a tenant, they must provide a reason why. So AB 3088 primarily involves protections for tenants who have struggled to pay rent due to COVID-19 financial stress reasons. So the major difference between AB 3088 and the CDC order is that AB 3088 does provide a requirement that the tenant's issue in paying rent be related to COVID-19 in some way. And in the next slide, I'll discuss what some possible loss of income or financial stress examples might be. And it also requires tenants to provide a declaration for non-payment of rent cases. And I'll provide more detail about that in the next slide. And there are increased penalties for landlords who engage in retaliation, illegal lockouts, harassing behavior. And AB 3088 is intended to be a temporary fix. So we can expect more legislation coming up in the new year. So just keep that in mind. We should expect kind of more, hopefully, protections in the new year and just more clarity about, what is allowed to happen and what's not. So tenants should keep in mind that the local county or city might have more protective ordinances preventing or temporarily banning certain evictions during the coronavirus pandemic. So keep that in mind. Even if AB 3088 might make it seem that a tenant can be evicted, there is a possibility the local ordinance might have stronger protections. Okay, so in AB 3088, there are two timeframes tenants need to be aware of. Well, first, let me just say that the notice period is longer than typical. So the notice period is 15 court days instead of 3 days. So let's say you get a notice for non-payment of rent. You have 15 court days to follow this process of providing a declaration and all of that, rather than 3 days to cure, to pay rent or leave. So the two timeframes people need to be aware of is March 1st to 2020 to August 31st, 2020. So in this case, non-payment of some or all of a tenant's rent cannot be the basis for eviction as long as the tenant provides a declaration to their landlord within 15 court days, stating that the non-payment of rent was related to COVID-19 financial stress. The landlord, when serving the tenant with a notice, must provide a copy of a blank declaration. So I'm not sure if folks were able to see a copy of the declaration, but if not, I sent it out, but if not, you can click on this link. It should be a clickable PDF. And if a tenant does not provide a signed declaration within 15 business days, the landlord can proceed with an eviction lawsuit. So just keep that in mind. It's really important that tenants get the declaration in. So the second time frame to be aware of is September 1st, 2020 to January 31st, 2021. So in this case, a little bit more is required of the tenant. So non-payment of some or all of the rent during this time frame cannot be a basis for eviction as long as the tenant timely provides the declaration, and they need to do that every single month and pay at least 25% of the total rent due during the time frame. And it is okay if that 25% is paid at the end of January. So I have a list in my notes about, this is listed in the declaration, but some examples of COVID-related financial stress include just simply loss of income because of COVID. So you lose your job, for example. Increased out-of-pocket expenses directly related to performing essential work during the COVID-19 pandemic. Increased expenses directly related to health impacts of COVID-19, childcare responsibilities or responsibilities to care for an elderly, disabled, or sick family member directly related to COVID-19 that limit the tenant's ability to earn income. Increased costs for childcare or attending to an elderly, disabled, or sick family member directly related to COVID-19, or is kind of a catch-all, other circumstances related to COVID-19 that have reduced my income or increased my expenses. So that all of that language is in the declaration. And then also, this is important, please note that any unpaid rent can be converted to civil debt, which a landlord can sue on in small claims court. AB 3088 also raises the cap to sue in small claims court. So if the unpaid debt is more than 10,000, the landlord can still sue in small claims court. I can't remember off the top of my head what the cap is now, but I can look that up.
So I see we have about 10 more minutes and there are some questions. So
I think we're almost done. So why don't I just, I'll try to do my best to get through this and then open it up to questions.
sounds good.
Okay. So Alameda County, I assume a lot of people here are either live in Alameda County or have clients who do. So this eviction moratorium has been in effect this whole time, and it is quite strong. So it temporarily bans all evictions in the county except for reasons related to health and safety, landlord withdrawing the unit from the rental market. The unit must be vacated to comply with a government agency or court order. And if a landlord violates the moratorium, it's an affirmative defense in an eviction lawsuit. So let's say a tenant is has an eviction filed against them. If the landlord violated the moratorium, that violation can be a defense to the eviction. So an affirmative defense means, this is just a fact that happened, and therefore I shouldn't be evicted. And if a landlord violates the moratorium, they can also be subject to a $1,000 fine and a possible civil lawsuit. And the expiration date is 60 days after the end of the local emergency. So whenever that local emergency is officially lifted, or 60 days after December 31st, 2020, whichever is later. And then, so just keep in mind that Alameda County likely provides more protection against eviction than AB 3088 or the CDC order do. That doesn't mean that tenants aren't required to comply with those orders, or landlords aren't either, but just if a tenant receives an eviction notice or a notice saying that they need to pay rent or quit, or any other type of notice before an eviction is actually filed, the tenant needs to make sure that they seek legal assistance to make sure that they understand what their rights are, and that they are receiving the full extent of protections under the law. As I mentioned, it is quite complicated, so having the help of an eviction defense attorney will be really necessary. Okay, yeah, so I'm happy to answer any questions that have come through.
Yeah, so someone asked, some of them that are more detailed, I might just say this is more detailed, so probably need a HERA and we won't dive into it. But there was one about tenants' rights of having an individual mailbox. I don't know if there's anything in the law about that, or
Individual mailbox.
yeah, sounds like a HERA question to call to dig deeper into it.
Yeah, I mean, I need to know a little bit more.
Okay, then there's another one about, can a landlord charge carpet cleaning fees when the tenant has lived there for 7 years prior to moving out? So is that, how long would that be considered?
I'm pretty sure that there are kind of, in the law, there's kind of like listings of it, but I think it depends, on what the tenant does. The tenant should definitely, I mean, if it's been 7 years and the tenant didn't take pictures when they first moved in, it's obviously too late for that, but it could fall within normal wear or tear. I would just be, it is a little tricky because the landlord might be able to say, well, it's not as clean as it was when,
Right.
the tenant first moved in. But to the extent that the tenant can clean the carpet, I know I have seen clients who have just paid for, when they moved out, paid to have a cleaner come and clean the carpet, and then it not be deducted. But then in that case, the landlord can't, obviously deduct for cleaning fees as long as the tenant has provided documentation. But it does get a little, there's definitely gray area there.
So that sounds like it relates to another question about tenants taking care of the repairs themselves. So
yeah, but it does get,
repairs and all of that.
to some extent, you could say, well, that's just normal wear and tear. Yeah, so I would have to know a little bit more about the situation. I mean, it's one thing if, there's a huge stain on the carpet, right? Then the landlord might be able to deduct for that. But if it's, maybe the carpet just faded, that could just be more of an example of normal wear and tear. So it just depends more on what the other facts are, if they're available.
Okay, here's a question. If someone is 3 months behind in their rent, but paying partial payments, not able to catch up, what can they do and how long will they be protected by the COVID-19 laws?
What county is this?
Let's assume Alameda, because
well, so they can't be evicted for not paying right now. So
okay,
since it's Alameda County, most likely they have, until 60 days after December 31st or 60 days after the local emergency has been lifted. But that doesn't mean they shouldn't do anything. They're probably required to follow the declaration, the CDC declaration requirements, or they should just, try to seek assistance. I know that there are a few organizations in Alameda County that actually do provide financial assistance to pay rent. So they might, I have the phone numbers. Actually, maybe I'll just go to that. To the slide. So Centrally Galled does have a fund to help folks during coronavirus. I don't know, I don't know the requirements and all of that, but I know some folks are getting help from Central Legal. There's also Bay Area Community Services, I believe, BACS, and then Catholic Charities. I can provide that. I'll make a note. I don't know kind of what their current status is in terms of the funds that are available, but there are organizations that are helping tenants pay rent during this time.
That's great.
Yeah. So the person should definitely, be prepared. They might have to, if the landlord does file an eviction, they would definitely have to provide all the declarations that I was talking about earlier. So just be prepared, in case that happens. And then to the extent possible, try to get financial assistance.
Okay.
Yeah.
One more quick question. The rest, I think, will likely need to go people to call HERA. Sorry, and we're running out of time, but can landlords raise your rent right after you ask for repairs to be completed?
That sounds really concerning. I mean, it sounds like it could potentially be retaliation if they're asked, I don't want to make assumptions, but it would depend on like the time frame. Has the landlord, raised the rent in the last year? How much are they trying to raise the rent? But if the tenant is asking, invoking their rights to live in a habitable unit, or asking the landlord to do something they're required to do, and then immediately after the landlord raises their rent, I mean, it's definitely, it seems a little bit suspicious to me, but I would want to kind of see what the other circumstances are around that.
Right.
Yeah.
Then there's a question about Airbnb and COVID and someone staying in an Airbnb, and it looks a little more detailed than what we can probably cover today. I'm really sorry.
That's okay.
I would really encourage people. I mean, HERA is an awesome, awesome organization to help with these kind of specific questions. So please feel free to call them. You can see the numbers on the screen.
Oh yeah, here, let me go to the next. So here's our services.
There
This is everything that we cover and we can talk about with folks. So here our phone numbers at the bottom and our website.
Yeah. We've put some of that stuff. And for any of you that want to relook at this training, we have recorded it and we will post it to our YouTube channel, which I have posted in the chat, and we'll go up and try to find it again. There it is, and post it again. And we will be sending you all the information that you've participated and or heard today. So you'll have all of that. And gosh, Nisha, I want to thank you. This is such a conversation, and so at this time in our world, such an important conversation. We're so grateful you are here today, and grateful to everybody for being here. And we really appreciate you to fill out your evaluation and let us know what more you need, so we can be available to help with that.
Yeah, thanks everyone. I'm sorry I wasn't able to get to everyone's questions, but definitely feel free to call HERA. We are happy to help and answer any questions you might have.
Yeah, it's just wonderful. I mean, my heart just starts beating when I hear all the questions, because I think, man, there's just not enough support for people right now. So, yeah. So thank you again. Thank you, everyone. Thank you for all of the work you're doing. I can tell from the questions that people are out there just supporting our community and helping people. Thank you. Thank you. We've got to help each other. And we're going to go ahead and end this training right now.